Mede enchasonko ema daily trends etiefo enyina sabre daily trends da de bremu eno abia ena ene esande eba omangana nsem yensem no yenko na yenkuti ensem a ewo ho
wo Accra High Court ene court no ekwa asetena ni nyina no chairman Wontumi the Ashanti Regional Chairman of the New Patriotic Party in case Egusua Ekoso Ewo Court that is talking about the Exim Bank case. No, yes, for you to know, Chairman Wontumi or cases are Sabrina or Kahwasem, not only one case. Exim Bank in one of them, and then Summer Boy, and so Ediano another, and then yes, other cases, and so. Now, talking about the Exim Bank case. Sabre court no ekwasitina the akoye ni say the counsel for the defendant omo edeko say ebeya enka court no emma omo time kakra say no they've submitted omo the application koi say court no ma ho kwan na plea bargaining because on interest say no maje e dia two say no kwadu dia bom no at least they now plea bargaining naturally said they should negotiate na bibia so entimi enkoso on the matter now for the negotiations near the keka ho no na omo say sisi an looking at the time I wo ho no nya dey some betimi the time one way or the other is shut so court no omo side the court say court no more time extension kakra to the case no na court no etimi etina say na court no etimi age ede atu court no etina se no court no etimi age ede atuma sisi reporter sabre ka yensa kire se court no I extend time no at the court 27th of July omo ede ebetena assembly so na kire se bibia so etimi akoso so the time them the space them no from now till 27th and I wanna any of the plea negotiations because that will be between the defendant, then the prosecution. It will be between the defense and then the Attorney General's department. So that will be how things will go. And then negotiations are because this was being made known by one of the council the Chairman Wontumi ono ene de sansem we de atu ya be kwade akoti no ebra court no etina se ekasa awiye no ene de sansem we de ebetu gana na quote few words and then before say ebeko ne akoti no say this is the Exim Bank case. We are yet to begin the substantive hearing as this is the first matter in which the lawyers for the accused and the Attorney General's department have opted for plea bargaining. Today in court, we requested additional time to continue the negotiations. The court granted the request and adjourned proceedings to 27th July 2026. We hope to reach a settlement by then. Between the defense and the prosecution, no, court proceeding. The council for Chairman Wontumi omo abrifie kakra na ewia de ohono yetimi ade atoaso
the lawyer kai we Exim Bank case no yenya nhyase this is the case edikan ababontin say lawyers for the accused person any Attorney General plea negotiations enya enwi pay enti ene back court no ya to court no anim say be here more time say betimi ayesa negotiations no na ewie a ne pomasi brand here da bedom court no so tiase ti wa agenda 27th of July hope say endru ho no na ya ye enhyehyɛ ya bia fa ho awie a na da bedom court no na court no
yes, the Attorney General Dominic Ayine should I move on and the Deputy Attorney General side, the two of them are prosecuting. We also know that Attorney General had already done the very bizarre thing by holding press conferences and almost certainly pronouncing the accused as guilty when that was not really part of his job. His job was to prosecute and allow the court to pronounce guilty. Tonight, the case has run to a certain level. It has gotten to an important threshold, an epoch. What is that EPO? When criminal trials begin, the prosecution will usually present their case. Presenting their case means that they will tell the court why they are prosecuting the individual, and then they will bring people, they call them witnesses. So prosecution witnesses. So when you go to court and you hear they say PW 16 is the 16th prosecution witness. P for prosecution, W for witness. So PW 1 up to wherever they choose, and the prosecution has the liberty to choose whatever they want. So the PWs have been interviewed. Interview means that they will call their names and then they will stand in the dock, and the attorney general or the one prosecuting, they call it examination in chief. They will ask them questions and then try to guide them to sort of give evidence and backing, give evidence and a lot of backing to the statements that the prosecution have made. When they have given this examination in chief, the lawyer of the one being prosecuted is allowed to ask them questions for clarification, to observe contradictions, and also to bring out certain information that will hopefully build up the case of the defense. When that has finished, and that is where they are in the Dubois case, that has finished now. When that has finished, then the defense counsel will also call its witnesses. And then when they come, the defense counsel will ask them questions, and he will be hoping that in asking them these questions, they will be dislodging the matters that have already been put before the court by the prosecution's witness. When defense counsel asks those questions, the prosecution is allowed also to cross-examine. In fact, there's a third level to it. If you ask your examination in chief and there's cross-examination, you can request the court that at the end of the cross-examination, you want to ask more questions, and that's called re-examination. So let's get that fast. I want to show you what is happening in the Dubois case, and you will be completely blown away, viewers. Let's move on. Now, there are two things that we need to learn today before we move on. Yeah, it's about the standard of proof. So when you go to court and they say you have to prove beyond reasonable doubt, what is the proof that this, where is the evidence that all that conversation is about the proof of the matter. PROOF, proof of the matter. So there's something called the standard of proof. The standard of proof investigates what should be the level, how much should we prove, what is the burden. We should, if we say that Paul Adomochi visited Professor Jenano Opoku-Agyeman yesterday, assuming that is a crime, and we want to establish it, to what extent should we establish that? Should we be able to have a photograph of Paul Adomochi standing in Jenano Opoku-Agyeman's house? Should we also add trace his phone so that the GPS will show on his phone that the phone was actually in Jenano Opoku-Agyeman's house? That may not be a complete proof that he was there with the phone, but if we can go ahead to say that he made a call at 9 o'clock and he spoke on the phone, and at that time the GPS showed that the phone was in Professor Jenano Opoku-Agyeman's house, then we are getting somewhere. So the standard of proof is, to what extent should we prove that this happened or that didn't happen? So standard of proof. This is from Black's Law Dictionary, so you can always check. It's a law dictionary called Black's Law Dictionary. You can just Google it and find out. The standard of proof is the level of certainty and the amount of evidence required to prove a claim in court. It dictates how convincing the evidence must be for a judge or jury to decide in favor of one party over the other. And this is the important part. The standard of proof dictates how convincing the evidence must be for a judge or jury to decide in favor of one party or the other. So the standard of proof is by and large legislated upon. So what is the standard of proof? And what the courts and the Anglo-American common law have done is that they have just separated the standard of proof into one standard of proof for civil cases and another standard of proof for criminal cases. So let's get there and find out where we are. Okay, so this is the standard of proof for civil cases. On what is a civil case, by the way? A civil case is the one that doesn't involve the government and the attorney general. It doesn't involve the police. The attorney general can also sue you in a civil action. Yeah, but normally when we see a civil case, it's between one Ghanaian and another. It could be one foreigner who has right to practice business in Ghana and he's angry with something he's suing. So two civilians, two individuals, no one is calling police to arrest anyone. Criminal cases are different. Criminal cases are prosecution by the state against an individual, and the state is involved because one individual has reported to the state that another Ghanaian or some foreigner who has to be in Ghana has done something against me, that's something that he has done against me, you will find it in the Criminal Offences Act. There is a document called the Criminal Offences Act where all prohibitions have been listed. So if you go to the Criminal Offences Act, which is Act 29 of 1960, but as amended, you will find one, they say stealing, they define it. This, they define it, defrauding by false pretenses. So if the action that has happened can be found in the Criminal Offences Act, you are free to go and report to the police that this person has stolen my money. The police will prosecute. That's criminal prosecution. So this is the civil one. On the balance of probabilities, what does it mean? It is the standard of proof used in civil court cases. It means that a claim is more likely to be true than not to be true, or that there is a greater than 50% chance that the event occurred. And I like the way they put it. So in civil matters, I'm suing Professor Jenan Opoku-Agyeman, or I'm suing Kwesi Pratt, or Kweku Baako is suing somebody, or somebody is suing Haruna Atta or something. If individuals are suing each other, what they are expected to do in court is that they would have to show that there is a greater than 50% chance that happened. So when the judge is looking at the evidence, he's trying to see whether there's a more than 50% chance that happened. So for instance, a case against a civil matter where Paul Adumochi has been sued, and I am saying that I wrote a letter to President John Dramani Mahama on the 16th of May. And then I am saying that's my defense, that the legal action against me evaporates if it is true that I wrote a letter to President John Dramani Mahama. So somebody is saying I've done something. I said I haven't done that because I wrote a letter to President Mahama. So the court is now looking as a civil matter. So more than 50% must be established. So the court finds out that they say that I wrote a letter to President John Dramani Mahama. I say yes. I said I wrote a letter to President Mahama. Then they come and say, where is the letter? I bring the letter to the court. The court looks at it. They admit it in evidence. And then the people against me say that, listen, you said you wrote this letter to President Mahama. I said, yes, I did. And you signed it. I said, yes, I signed it. They said, okay. That was on 23rd May. I said, yes. Okay. So they bring another letter. They say, okay, this letter, which was written in 2023, when you were a board member at the National Communication Authority at NCA, you wrote it. I said, yes, I wrote it. They give the letter to me. Can you recognize? I said, I can recognize it. You wrote it. I wrote it. It says your signature